Alrighty, well, good morning, everyone. It's exactly 9 o'clock in the morning, and we have 11 participants on the call. So I will turn it over to Albert to give you his presentation. Thanks for being here.
Thanks, Andrea. And thanks everyone for attending today. I want to say that during the course of the presentation, if you have any questions, please feel free to just interrupt and give me your question then. I find it easier to do it that way than waiting till the end. So don't feel bad about just interrupting and interjecting your question. That's just fine with me. Just a little bit about myself. My name is Albert Schlotfeldt. I have the Schlotfeldt law firm. We've been longtime members of the BIA and practice mainly in real estate and construction law and business litigation. The topic which we're going to be talking about today, I'm sorry, my webcam, I got a new webcam, it's a little dark here, but the topic we're going to be talking about today is contracting strategies in the time of rising prices and shortages. So as you know, obviously, I'm not telling you anything you don't already know. We've had some interesting market conditions lately, one of which is, of course, rapidly rising prices, but not just rising prices, but also volatility in prices, material shortages in many different types of materials, labor shortages, and I've also heard problems with some lenders of delay in getting loans through underwriting. And then, of course, this is all compounded by the high demand that we've seen. So all of those things have an effect, of course, on the industry. And there are challenges that have come up that we need to learn how to deal with. I'll tell you just from the get-go that there's no perfect solution to any of this, but some of the things that I'm going to talk about are some ideas that you can do, at least contractually, to try to minimize some of these problems and give yourself some options when these problems arise. So, of course, what are some of the effects that we've seen? Well, one of the big things I've seen, of course, is contractors signing contracts to build a home or to sell a home that maybe is in a subdivision or pre-sale. But between that time and between the time they're ready to start work, there's significantly increased prices. Of course, then that might have eaten up all your profit. And in many cases, I've seen it actually go negative. So, and then, of course, that there's a delay in that time period between contract execution and commencement of construction. And then the other effect, of course, is during the course of construction, there are shortages, and this is more of a problem on the commercial side, maybe more than the residential side. But what we've seen is, of course, people are not able to keep their job schedules because things are just not available. And then, of course, we also had COVID. And sometimes you have an out in your contract clauses and sometimes you don't. The other sort of non-quantifiable problem that's occurred as a result of these market challenges is, of course, unhappy customers. I mean, people are mad because, they want to get in before September because the kids got to be at school, or they're going to a new school, they're moving from a different district, or the lease is going to be up on the place they're leasing and they need to get in. So these are some of the problems. And I've seen many situations where the subcontractors, of course, can't timely perform and sometimes just basically bail on the project. I've seen that happen here. And then, of course, the job cost overruns are eliminating profitability. And you may be stuck with a fixed price contract. And even worse, you may be stuck with a fixed price contract with a liquidated damages clause for delay, which compounds things even worse. So just a couple of do's and don'ts. And then I want to talk about some of the contract clauses and how they could help solve this problem a little bit for you. Is, first of all, if you can avoid it, you never want to commit to a hard deadline. There's always a temptation to say, to agree that, well, we can have the house done in 5 months or 4 months or 180 days or whatever the number is, but you just don't know what's going to happen. And what's happened in the past is no indicator of what might be happening in the future. I mean, this threads down through to the subcontractors also, because then they may get pushed to keep a deadline, and and they can't necessarily commit to that. And then secondly, it's, again, this is more of a problem on the commercial side, less so on the residential side, but you don't want to agree to a liquidated damage clause if you can avoid it. If you're really forced to get into a liquidated damage clause, you of course want to get the number down as low as you can, and you want to extend your schedule out as far as you can to minimize your risks. So there are some things, that we've been putting into contracts for people to try to deal with these issues rather. And I want to talk about some of them. One is a price escalation clause. Now, this is common sometimes in government contracting, especially in long duration projects, maybe less common in residential contracting. But the price escalation clause kind of comes in two main types, if you're not familiar with these. One is you can call out some specific materials that you're concerned about. And you could say some clauses are specific to those materials, because you could say, well, we've budgeted X number of dollars for lumber and X number of dollars for concrete. And if those items go up, then you owe us additional compensation for those additional costs. So that's a price escalation clause that's honed in very specifically to certain materials. And what's good about that? What's bad about that? Well, the good part is that from the owner's standpoint, they're often more comfortable with that because they know that it's just, we're just talking about certain materials that we're going to focus on, and it sort of limits their risk too. Now, what's the bad part? If you're the contractor or the subcontractor who's providing those materials, you might be providing a lot of other materials too. And so you may be controlling your costs on certain materials, but then, before you know it, your HVAC's gone up a lot, or some other things have gone up a lot that weren't in that clause. So you just have to kind of weigh where you're at and what you expect, what materials you really expect the price volatility to be in. So that's sort of the material specific type of clause. The other type of clause, of course, is sort of your overall cost. Again, sometimes you could temper this by saying, well, if my costs go up and anything above, let's just say a 5% increase, the first 5%, I'll eat it, as the contractor. I'll eat the first 5%, or I'll eat the first 8%, or whatever. And then anything above that, I'm entitled to additional compensation. The difficulty sometimes, though, is you then need to really reveal your cost and your costing information to make that work. So that sometimes is a conversation people don't want to have, and sometimes something that drives them more towards the material specific clauses for cost increases. And sometimes if you get pushback from owners, sometimes we'll say, well, we'll have a cap. We'll get increased costs if our costs increase, or increased payment if our costs increase above anything, say above a certain percentage, above 2% or above 5%. But then maybe you cap that at a certain amount. You cap that at whatever, 10%. I just pick a number. And then that way, sometimes that's, again, more palatable for the owner because they can build in a contingency and to try to handle that. So those are some ways that you can get price escalation clauses and try to also sell them to the owner in a way that might be more palatable to them and also to their lender. Of course, the challenge of all of this is how is this going to get paid? I mean, that's the issue. And the difficulty sometimes is some of the buyers or borrowers, of course, are already, tapping out what they can borrow, and they may not have the ability to borrow much more money or any more money, and they may not have a whole lot of cash. So there's always that difficulty. And I think but the lesson, I think, is to have that conversation at the front end before the contract's penned. And in a minute here, we're going to talk about some other types of contingency funds and so forth, but to make sure that there's some wiggle room or there's some movement there, an ability to do that. what do you do if you have the price escalation clause and then all of a sudden they can't borrow any more money and they don't have any more cash? Well, that's a problem. Even if, you're into it, you're already into the project. One thing that some people have been doing is taking back notes and deeds of trust. Now, what's the good part? The bad part about that is, well, of course, you'd like to get paid all in full at closing, right? But if there's no other way to fix the problem, maybe that's a second best option. Not a great option, but it's a second best option. You have to be a little bit cautious though, because taking back a note and deed of trust, of course, would be in second position to the primary lender. It may technically be a violation of the original loan. Now, as a practical matter, I don't think lenders, as long as their payments are getting made, they never go back really and look to see if something was recorded shortly after closing. So that's an option sometimes to try to get paid. The other thing that if you can do it is to have the conversation involving the lender again and talk about having a contingency fund. Now, sometimes there's contingency funds built into the loans, and sometimes you can tap them for certain things or certain circumstances. So if there is such a fund that gets built into the loan, and again, I see this more in commercial than residential, but if there is a contingency fund, make sure that there's no conditions for you as the builder to be able to tap into that money. In other words, make sure it doesn't say, well, you can use the contingency fund, but you can only use it under these circumstances. You really have to make sure you understand under what circumstances you'd be able to use that money. And the difficulty, of course, even if you have just a standard contingency fund like we see in some commercial projects, if you use it for price increases, then it's not there for other things. And sometimes you want it there for other things that are unexpected. Allowances, of course, allowance amounts are normally used simply for discretionary items. What are the people going to pay or choose for their appliances and so forth. But you can broaden some of that language, or you can have categories that might create essentially what's like an allowance item, or some other things that you might be concerned about that are price volatile. The next thing I want to talk about is termination clauses. Again, we've seen these for years in commercial contracts, not so often in residential contracts. Most contracts always have a termination for cause provision, meaning that if the person, whether it's the subcontractor or the contractor or even the owner, is not complying with the terms of the contract, the owner's not making their payments, or the contractors abandon the job or whatever, you can usually terminate under the termination for cause provisions. But in almost all contracts, the termination for cause provisions have some sort of a notice and opportunity to cure. This is your 48-hour notice, your 72-hour notice, and then you have an opportunity to correct the situation. That's a termination for clause or for cause provision. But termination for cause provisions really don't generally help you with price increases. So what might help you is a no cause termination provision, or what we call a termination for convenience. In other words, some contracts, again, we see this mostly in subcontracts between general contractors and the subcontractors we see it more in commercial, but there's no reason why you can't have it in residential, whereby you could say, I can terminate the contract with the owner for any reason on X days notice, 30 days notice, and I get paid in full for the work performed to date. Sometimes maybe you give them a little kicker back or whatever. But that's a termination for convenience clause. Now, as a practical matter, do you really want to do that? Do you want to be able to terminate for convenience? Sometimes you don't. Sometimes, the hope is really that you have that ability and I like to call these kinds of clauses, I like to call them escape hatches. You have a way to escape if you have to. But you maybe don't necessarily really want to do it, but it gives you the opportunity perhaps to renegotiate something, something that's more palatable to you in terms of costs or maybe completion dates and so forth. So it kind of might bring things to a head whereby they have an option is either you're going to just terminate for convenience or, maybe we need to renegotiate some of these things. So those are termination for convenience, or also called no cause termination provisions. No damage for delay. This is another provision that would help, of course, with the material shortage issues. I mean, you've all seen the different scenarios where, you're trying to get certificate of occupancy, but that particular stove that they ordered or particular item doesn't come in, and that item might be critical to getting your certificate of occupancy. So a no damage for delay clause is helpful. The other side of kind of corollary to that is a limitation on damages. So in other words, you could say you're not entitled to any damages resulting or originating because of delay in the project, because I can't guarantee this end date, and I'm not guaranteeing an end date. But you can also have other types of limitations of damages. This, for example, a common clause would be no incidental or consequential damages. So when someone breaches a contract, you often have what we call direct damages that result. Those are the things that happen that are directly connected to whatever the breach was. But then there's other things that might be incidental to that or consequential to that. For example, the direct damages might be the cost to complete the house, or the direct damages might be the cost to correct the defect in the work. But then someone might say, well, but as a consequence of this, I had delay in moving into my house, and so I had additional rental costs, or I lost my lock on my loan, so I have an additional interest rate and additional costs there. So no damages for delay and limitations on incidental and consequential damages. Why do you want that? Again, it puts you in a position where if everything goes awry and you can't get out of the contract and you're stuck with this fixed price, at least you can try to minimize your exposure, just trying to reduce the damage, so to speak, if you can. The next thing I want to talk about, which has been very misunderstood during COVID, for example, is the force majeure clauses or act of God clauses. Typically, those clauses are in most contracts, and it says, I'm not responsible for delay that's beyond my control. But if you read most of those clauses, almost all of them relate to weather events. For example, unusual rainfall or unusual snowfall. So a couple of things to realize about force majeure clauses. That first of all, just because there's been a bunch of rain or a bunch of snow doesn't necessarily give you more time. The way most of these clauses are worded, it is more than usual. So if we normally get a certain amount of rain or a certain amount of snow, that doesn't give you more time under the force majeure clause, but something that's out of the ordinary is what gives you additional time. Now, during the pandemic, I saw a lot of people saying, well, I get more time because there's been this government shutdown because I have a force majeure clause. Well, the problem is most force majeure clauses were not written broadly enough to incorporate things like government shutdowns, material shortages, things related to the pandemic, etc. They just weren't worded that broadly because, frankly, it was just things that hadn't happened before, or it hadn't happened in 50 years. So I guess one tip to all of you is you need to, if your contract contains a force majeure clause, and it probably does, you're going to want to think about broadening the wording of that. so that there are more things included in that definition of force majeure. And the more things included in there is going to potentially give you more options for additional time, and of course, consequently, minimize your exposure. So those are force majeure clauses, but you really have to rework the wording of them to make sure that they're expanded enough to cover things like material shortages and government shutdowns, et cetera, et cetera. Shortages. Shortages, of course, of certain materials are a problem. And sometimes, I mean, not, I shouldn't say sometimes, almost all the time, clients, the owners have picked out certain items. They want certain particular items. In commercial, we see a lot of times the architects spec out a certain type of HVAC unit because whatever, it's their favorite, I don't know. But so how do you get around that if all of a sudden you find out that the item that the customer or the owner has picked or the architect has spec'd is either severely delayed or simply just not available? That's going to be a problem because you may not be able to get certificate of occupancy and you may lose your schedule. So how do you solve that? You have what we call a alternates clause, and an alternates clause is simply a clause that says, you know, even if you spec'd out a certain thing, a certain product, if it's not available or available in a reasonable amount of time, I have the opportunity, I as the general or I as the sub, have the ability to substitute an alternate as long as the alternate has basically the same performance specifications. So even though they called out a certain brand, certain type, if that's not available, you can get in an alternate and put in that other item and then stay on track and stay on schedule. The other, with some things like home appliances, of course, I've seen some contractors just saying, hey, you know, the one you spec'd isn't available. We can just go buy a cheap one for now from Home Depot or someplace and just hook that up at least temporarily so we can get C of O, and then we'll get you the one that you actually asked for. But an alternates clause gives you a lot more flexibility. Anti-assignment clauses. Now, this is important for general contractors and for subcontractors, and this relates mainly to the issue of the labor shortages. So your drywaller or your electrician, whoever, can't get enough workers, and so they're in a pinch, and they then subcontract. It would really be what we call a second tier subcontract with another drywaller or another electrician, and to bring on some of their personnel to help staff this job. Well, I mean, on one hand, you say, well, that's good because they're going to get the work done, and you know, we're going to stay on schedule and everything's great. On the other hand, it's very bad from the general contractor standpoint because you may not know who's really working on your job. You may think it's electrician A, but it's really electrician B, or it's part electrician A and part electrician B. So what's the problem with that? Well, there's a lot of problems with that because you don't have a subcontract with electrician B, and you haven't obtained their licensing information, and you haven't obtained their insurance information, and you haven't been named as an additional named insured. And depending on how the money's flowing, I have seen situations where electrician B says, hey, we were bought onto this job, but we don't have a contract with the owner, and you know, we weren't on a fixed price or whatever. So it can be an issue. So how do you try to control that? Well, you can have an anti-assignment clause, which basically says, subcontractor, you cannot assign all or a portion of your work without my permission. And if you want to temper that even more, you could say, and my permission won't be unreasonably withheld, but as a condition for me giving permission for you to assign part of your work, there's going to have to be some conditions, and that is the party who's the second tier subcontractor is going to have to sign a contract It's going to have the indemnity provisions. It's going to have the insurance provisions. They're going to have to provide us with proof of licensing and proof of insurance and so forth. So you allow it, but you allow it in an organized way, not a sort of undercover way. Because I've had situations even on commercial projects where all of a sudden the general goes, who are these guys? Why are they here? We don't even know who these people are. And then you find out, well, the other subcontractor has assigned a part of their work. I guess the bottom line of all of this is that with the market challenges that we're facing right now, there's really no perfect solution, but there are things that you can put in your contract to either give you a way out, like what I like to say is an escape hatch, or allow you to adjust the price, and also have other clauses to minimize your damages. So either get out, adjust the price, or even if I have to take a hit, my damages are going to be minimized and reduced. And that's the last type of clauses I was discussing here in a moment. So that's about all I had for a formal presentation. I'm willing to take any questions or have anybody raise any issues that they might have. Feel free to just chime in if you do. Anybody? Okay. Well, Andrea, you want to come back on?
Sure. Yeah. Thank you so much, Albert. That was really great information.
Yeah.
We will send this out to everybody that's on here in case they want to rewatch it. And then we'll send it out to the rest of the membership as well. If anybody has any questions that maybe are lingering later on in the day, feel free to email those to me and I can pass those on to Albert or pass on his contact information, whichever. Thank you again, and thank you for joining us, everyone, and have a great day.
All right. Thanks, everybody. Bye-bye.